motor vehicle accident and a father is driving the car, meets an accident, and his child dies in the accident, and he's negligent. So do you prosecute the father who has really suffered a lot already, and there isn't a lot of damage to the other vehicle? You look at those factors and you think, on humanitarian grounds, this is a case that you don't prosecute, even though on the face of it, he was clearly negligent and should be prosecuted. There might be an instance where a victim or an accused person might be extremely ill, and you would decide that, or very old or very young, and you decide that you would not prosecute. So there's those kinds of factors that a prosecutor would consider. I must say that although this issue doesn't fall into prosecution public interest matters, that given the various constraints that we have with resource and things like that, it's literally impossible to prosecute every case. And so you sometimes have to prioritize matters and decides which cases to take on first. But that's, generally when a case is serious, and, we would certainly not prioritize other matters. It's more the less serious matters that would kind of fall at the bottom of the inbox, so to speak, in terms of attention. But it is a factor you have to consider, but it's not, strictly speaking, public interest issue. Well, it's not a public interest issue at all. Thank you, Chair.
Thank you, Councillor. That helps.
Yeah, just one thing. I'm actually made to ask a question because of your answer, where you were trying to explain as to what could constitute public interest. And then you went further to talk about prioritizing cases. Now, prioritizing cases cannot be an equivalent of deciding whether to prosecute or not. Am I correct? All what you are saying is that, depending on what we see or the importance of cases, others may find themselves ending up just being pushed lower and lower in the cycle. But how far do you go with it? Because every day there will be cases that we will see, criminal cases that we see as very important, and there will also be those that are seen as being, just light offenses. So up to how far do you then keep pushing these ones that are seen as just non-important cases?
So let me be clear, it's less serious, but not necessarily not important. Mm-hmm. Every victim or complainant wants his or her justice, yes, even for the smallest of cases. And we have to be, as victims of crime we are lawyers for the people as prosecutors, and we defend the rights of victims, and primarily, but of course we must make sure that there's a fair trial and all of that ensues. But so we've got to strike that balance between, and look, the lower courts are full of those kinds of cases. It's not like we don't prosecute cases, the less serious cases. The district courts are full of them. So at the different levels, for example, the more serious matters, you may decide to choose, prioritize a matter because of the high profile nature, because of potential reputation, high impact matters, the matter that be reduction of harm issues, that's also considered. So there are various factors that we consider in prioritizing, but it's not like there's a decision not to prosecute, as you correctly said, because of that prioritization. It's just that others will be prioritized over others. Thank you.
Thank you.
Thank you, Madam Ramaha.
Yes, thank you, Council. You may proceed.
Thank you, Madam Chair. Advocate Batohi, I now direct your attention to paragraphs 32, 33, 30, 34. We'll deal with that later. In paragraph 32, you say, and that emanates from the provisions of section 179 of the Constitution. I don't think it's necessary for you to read into the record section 179(4) of the Constitution unless you deem it necessary. I think
If we have I don't have the Constitution in front of me, but I'm happy to read into the record. Thank you.
You can read into the record. Remember, we are here for the public and for the record.
I agree. Should we proceed?
You proceed, sir.
Advocate Batohi,
I'm just finding section 179. Okay, may I proceed? Chairperson?
proceed please to read it into the record.
Thank you.
Just 179(4).
So section 179 is the part of the Constitution. It's headed the prosecuting authority. And so section 179(1), for the purpose of completeness, as the judge said, we are speaking to the public as well, creates a single national prosecuting authority, as I mentioned earlier on. And it deals with the structure in terms of the NDPP and DPPs. 179(2) is also important because it sets out the power. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out necessary functions incidental to instituting criminal proceedings. Subsection 3 states that national legislation must ensure that the directors of public prosecutions are appropriately qualified and are responsible for prosecutions in specific jurisdictions subject to subsection 5. Then subsection 4 reads, national legislation must ensure that a prosecuting authority, this is the important section you wanted me to go to, Council. National legislation must ensure that the prosecuting authority exercise its function without fear, favor, or prejudice. Subsection 5 then deals with the NDPP's function to determine, with the concurrence of the minister and after consultation with DPPs, the prosecution policy, which we talked about, and subsection 5B talks, the NDPP must issue policy directives which must be observed in the prosecution process. Going to 5C, it states that the NDPP may intervene and this in the review process. And this was the section that I was thinking about earlier on. It is section 179(5)(c) of the Constitution, which gives the NDPP the power to intervene in a prosecution process when policy directives are not complied with. And D, may review a decision to prosecute or not to prosecute after consulting with the DPP and taking representations within a specific time from the following persons: the accused, the complainant, any other person or party whom the National Director considers to be relevant. Should I continue with the other subparagraphs? And the national legislation referred to in this section is, of course, the National Prosecuting Authority Act.
I want us to place our utmost attention to the terms used in subsection 4 of section 179, which you refer to in these paragraphs, at least in the two that has been referred to, that is 32 and 33. wherein it is required of a prosecutor to exercise his or her discretion, or when executing his or her functions, to act without fear, favor, or prejudice.
So as I indicated, Section 1794 of the Constitution provides that the NPA must exercise its functions without fear, favor, or prejudice. And the Constitutional Court has held that in terms of this provision, there is a constitutional guarantee of the independence of the prosecuting authority. And any legislation or executive action inconsistent with this would be subject to constitutional control by the courts. Section 32(1)(a) then of the NPA Act carries this obligation forward and provides that all members of the NPA must serve impartially and exercise, carry out, or perform their functions, duties, and perform their powers, duties, and functions in good faith without fear, favor, or prejudice, and subject only to the Constitution and the law. And taking this further, subsection B of section 1B of section 32 further states that that subject to the Constitution and the Act, the NPA Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its powers, his or her powers, functions, and duties. And in the NPA Act, section 41(1), in fact, proscribes the contravention of this section. And as I said, these provisions give effect to section 1794 of the Constitution in terms of guaranteeing the NPA's independence.
These phrases, fear, favor, or prejudice, reverberates throughout the NPA Act as contained in the Constitution. Can you put them within context? What is fear? When can we say a prosecutor fears? When can we say a prosecutor favors? When can we say a prosecutor is prejudiced?
So I think the latter two are a bit easier to deal with. Favor is, of course, where you don't prosecute someone because you know the person for whatever reason. You know, it could be a friend, it could be a colleague. You favor that person. It could be a member of the executive. So that is, it's not prosecuting without favor. Prejudice, of course, would be the opposite. If you prosecute persons that you should not be, that would clearly cause prejudice to the persons concerned. The aspect of fear is, of course, it's meant to convey that in making our prosecutorial decisions, we should be fearful of nothing. You should not be fearful of the fact that you might be targeted for any reason, the fact that a member of the executive might victimize you. You have to do your job and base your decision on the evidence that is before you. Having said that, I must say, although prosecutors still, I certainly hope that the majority of prosecutors in the NPA do exactly that and understand their oath of office to do this, an oath that we take in terms of the code of conduct. I must say that the circumstances in South Africa this day lead many people to become fearful for the work that they do because of attacks on prosecutors, witnesses, etc. But the concept of fear in the context of the Constitution is, as I indicated earlier, that we base our decisions only on the evidence in front of us in the docket, and we don't allow any fears that we may have for some of the consequences that I spoke about earlier to affect our decision to prosecute. In fact, if a prosecutor is fearful for any reason, and it's not unthinkable that may happen, then the prosecutor should inform the supervisor and withdraw from the case, but not take a decision that might be influenced by this fear in any way. Thank you.
Doesn't it follow then that if the prosecutor is fearful, he or she is not fit to hold the office?
Fearful in the context of the consequences I first mentioned, I would certainly agree with that. But the conditions that we're working on, if they're fearful because of threats on their lives, then of course it doesn't mean that they're not fit to do their jobs. We have to look at security. There might be really good prosecutors that are threatened. But if a prosecutor is fearful in the first context and then takes a decision on, I fully agree, they're not fit to hold office.
Proceed, Council.
Thank you, Madam Chair. Let us now focus our attention on the subtopic contained on page 19 of your affidavit, where you deal with the structure of the NPA. Briefly, just explain it in accordance with what is contained in section 179, 1 and 3 of the Constitution. Just in brief.
Yes, thank you, Council. So in terms of the Constitution and that section 179, 1 and 3, and the NPA Act, section 5 and 6, the structure of the prosecuting authority is essentially, as it says, there are two offices. You have the Office of the National Director, and then you have the Office of the DPP in the provinces.
Hold it there. Let me interject you.
Mm-hmm.
Let us explain fully what a DPP is.
Yes. So there's a Director of Public Prosecution, and Chairperson, you'll note in paragraph 36, I refer to section section 6 DPP. And that is specifically mentioned because the section 6 DPP is what will be the provincial head in the structure. But there are other special DPPs, special directors of public prosecutions, that are appointed, and they are generally based at the head office, and they have a specific area of work. For example, we have a special DPP in charge of specialized commercial crime units. We have a special DPP that deals with priority crimes, for example, the TRC matters. Well, no, not the TRC anymore. That's been removed from this particular unit. But looking at terrorism matters, looking at international crimes, there's a special director of public prosecutions. So that and of course we have the investigating director now, who is also at a DPP level, but is the head of the investigating directorate against corruption. So the section 6 DPPs it's dealt specifically with in paragraph 38. Perhaps I'll just deal with the national office of the NDPP to start off with. This office is at the head office on paragraph 37, is at the head office and provides that the office of the national director consists of the national director, the deputy national directors, the investigating director, and special directors that I mentioned, other members of the prosecuting authority, for example, deputies, senior state advocates, prosecutors, all at the national office, as well as an administrative component. And then in paragraph 38, we move on to the office of the DPP, which is established at the seat of the High Court.
Allow me to interject. It will follow, therefore, that Advocate Chauke falls under the category of a Section 6 DPP.
Yes, that is correct, because he is the head of a province. So he is a Section 6 DPP, South Gauteng Division. And so a DPP office is established at the seat of the High Court, the provincial divisions of the High Court, and local divisions of the High Court. And as I say, they may be referred to as Section 6 DPPs. So this Section 6.2 of the Act provides that the DPP office consists of the following: of the head of the office, who's either a DPP or a deputy DPP. And maybe I should just explain the deputy DPP aspect. For example, in KwaZulu-Natal, you have a DPP in Pietermaritzburg, the seat of the provincial division of the High Court, and you have a local division. You also have a DPP office, but it's at the local division, and the head of that office is a deputy DPP, but who of course will report to the DPP in Pietermaritzburg.
Whilst you're on that, Advocate Batohi, you mentioned that Advocate Chauke heads the South Gauteng.
That's correct.
Division in Johannesburg.
That is correct.
There is a North Gauteng, in other words.
That is correct. That is in Pretoria.
You may proceed.
So the office of the DPP, Section 6 DPP, consists, of course, the head of the office, deputy DPPs, prosecutors, senior state advocates, junior state advocates. And the DPP also has jurisdiction over all of the prosecutors in the lower courts that falls within the DPP's area of jurisdiction. And we refer to Section 24 of the NPA Act.
Excuse me, Advocate Batohi, I think you are leaving us behind. I'm a bit confused about the Advocate Chauke being a Section 6 DPP South Gauteng, meaning Johannesburg. Does it, and then Pretoria jumped in. Can you assist?
Yeah, Gauteng province has two divisions. Johannesburg, one in Johannesburg, which is referred to as a local division. Not so.
That's correct.
There is a provincial division whose seat is in Pretoria.
That is correct.
It also has its own Section 6 DPP.
That's correct. So can I explain further? Maybe I can just try to clarify. This is one of the few provinces that has got two DPPs. It used to be the same in Eastern Cape, where there was a DPP seated in Mthatha and another DPP seat. So in Eastern, both in Eastern Cape, one in Mthatha, one in Grahamstown. And that's historic. I think it's also historic that Gauteng has two DPPs, as council has explained. So in Eastern Cape at the moment now we've kind of amalgamated and you have one DPP, but the same has not happened in Gauteng. But I suppose the demarcation process will deal with that. But for now, I don't think there's any, I'm not aware of any plans to have one DPP in the Gauteng division.
Is the position not occasioned by the fact that we have two seats of the High Court in Gauteng?
That is also, we do have two seats of the High Court.
You will therefore have a DPP South Gauteng and a DPP North Gauteng.
That is correct, Chairperson.
And if I'm correct, Advocate Chauke will be a DPP for the South Gauteng division.
That is correct, Chairperson. And the office is situated in Johannesburg, but the division, of course, is much broader.
Just a follow-up. So in the case of Gauteng, we have two DPPs, Pretoria seat and the Johannesburg seat. Now, in respect of KZN, do you have two DPPs or do you have a DPP and an NDPP?
You're not an NDPP, you have a DPP in Pietermaritzburg, which is a provincial division. And in the local division in Durban, you have a deputy as the head of that office. There's no two DPPs in KZN.
Okay,
It's
so-
one DPP for the KZN province.
Right, thank you.
Yes, sir.
Thanks, Madam Chair. Let us now leap over to page 21.
I should maybe, sorry, Council, if I may, just
Yes, you
before,
may.
I was dealing with section 38 with the office. I want to point out section 38 in terms of section 38. We can also, and we could go to the section 38 of the Act, which I have the NPA Act. If I may refer to that quickly, Chairperson. I was asked a question earlier about additional support, and just to bring to the attention of the panel that section 38 of the NPA Act allows for the appointment of outside counsel where the need arises. The NDPP may, in consultation with the minister, deputy, that's 38(1), and director, engage under agreements in writing persons having suitable qualifications and experience to perform specific services in specific cases. So just to explain that is where external counsel are appointed in terms of that section. And of course, the DPP's office also has an administrative component, which consists of HR, finance, security and risk, communications, and other related administrative sections.
Are you fine with that? Let's leap over to paragraph 42, where you deal with the National Director of Public Prosecutions. Let's go to the Act. Before we get into this one, let's go to the Act. Section, I'll tell you, 24. I'll ask you to read into the record, section 24. Section 24, subsection 1AB, CD, 2, yes, up to 2, for current purposes.
So section 24 is headed powers, duties, and functions of directors and deputy directors of public prosecutions. It relates to the functions of DPPs and deputy DPPs. Subsection 1 of section 24 states, subject to the provisions of section 179 and any other relevant section of the Constitution, this Act, any other section of the Constitution, this Act, or any other law, a director referred to in section 13(1)(a) has, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings and to carry out functions incidental thereto, as contemplated in section 23. B, supervise, direct, and coordinate the work and activities of all deputy directors and prosecutors in the office of which he or she is the head. C, supervise, direct, and coordinate specific investigations. And D, carry out all duties and perform all functions and exercise all powers conferred or imposed on or assigned to him or her under any law which is in accordance with the provision of this Act. Subsection 2 of Section 24 reads, in addition to the powers, duties, and functions conferred or imposed on or assigned to an investigating director. Well, I'm not sure subsection 2 is relevant unless the chairperson wants me to read it, because that deals specifically to the IDAC, which is not the subject of this inquiry.
I agree. I'm with you. Just skip it.
Subsection 3 deals with the special DPPs that I mentioned as well
Yes.
earlier on. Perhaps subsection 4, in addition to any other powers, duties, and functions conferred or imposed on or assigned to him or her by Section 179 of the Constitution, this Act or any other law, a director referred to in Section 13(1) shall, at the request of the National Director, submit reports to the National Director or assist the National Director in connection with a matter referred to in Section 22(4)(a) Roman 2. B, shall submit annual reports to the National Director pertaining to matters referred to in Section 22(4)(g). C, may, in the case of a director referred to in Section 13(1)(a), give written directions or furnish guidelines to the Provincial Commissioner of Police, referred to in Section 207(3) of the Constitution, within his or her area of jurisdiction, or Roman 2, any other person who within his or her area of jurisdiction conducts investigations in relation to offenses, that's AA, or BB, other than a private prosecutor, institutes or carries on prosecutions for offenses. And D, shall, subject to the directions of the National Director, be responsible for the day-to-day management of the deputy directors and prosecutors under his or her control. Should I read subsection 5? Sorry.
For the moment, you may skip subsection 5 and 6. Jump over to 8, subsection 8.
Subsection 8 of Section 24 reads, the powers conferred upon a director under Section 21 shall include the authority to prosecute in any court any appeal arising from criminal proceedings.
I want to take you back, Advocate Batohi, to Section 24.
To which section? 24.
24. Not in its entirety, but 24(1). I want you, for the benefit not only of the panel, but for the benefit of anyone who, beg your pardon, who interprets this section, to clearly understand what it entails. And I'll refer you to the phrase that I want our attention to be directed to. After Section 13(1)(a) in subsection 1, there's a word there that says has, and it has a comma. It says, after the comma, it says, in respect of the area for which he or she has been appointed. That is crucial. It is important, and one must, when one reads this, must read it with an eye of a hawk and with caution. Can you comment?
Yes, so Chairperson, this Section 24(1) makes it clear that a DPP must exercise his powers or her powers and functions in respect of your area of jurisdiction. So the words in subsection 1, which says in respect of the area for which he or she has been appointed, a section 6 DPP is appointed to a particular jurisdiction. For example, it would be KwaZulu-Natal or the Free State, and that DPP is able to exercise, has the power to exercise functions and duties with regard to that particular area of jurisdiction. You can do all of the things below that that are listed in subsection 1A, B, C, and D of section 24, provided that it is in respect of the area for which the DPP has been appointed. So that is a very important jurisdictional issue. You have no power to do that in another area or a case that is in another jurisdiction.
Thank you. We know that in law, for every rule, for every general rule, there are exceptions. Are there exceptions in this instance? If any, can you explain them, how they come into play?
No, I'm not aware of a DPP. I am not aware of a DPP of one jurisdiction exercising powers in another jurisdiction. In fact, if I'm not mistaken, Mohoro Commission as well specifically dealt with this matter, indicating that a DPP has no power or authority in another jurisdiction. And I'm not aware that this has happened. I do want to say that special DPPs, that's not a section 6 DPPs, the SDPPs, who I mentioned earlier, who have, like we have an SDPP in charge of the sexual offenses unit, they have jurisdiction over the entire country, and they can assist the DPPs in any part of the country. But that's not a section 6 DPP. That's a distinction.
Advocate Batohi, will there be circumstances, for instance, where a section 6 DPP would get into an area of another section 6 DPP, in other words, in another jurisdiction, and perform prosecutorial duties there?
Not if you haven't been properly appointed as such.
Explain it, how and when it can happen.
If a DPP of one division is also appointed, for example, to act in another division, that is an appointment. So it's a section 6 DPP. But of course, there will have to be someone in that, the region where the DPP comes from, to be appointed to act there as well. But it's not the instance of a DPP appointed in a specific area. There's never been a case when a DPP of, for example, Northern Cape can exercise jurisdiction over the Free State. So let me also say, when there's a case that's centralized, right? I think I should bring this. There's a section in the Act that allows the National Director to centralize cases. So let's assume there's a matter that starts off in KwaZulu-Natal, and then there's some case charges that are in Johannesburg, in Gauteng. Then the DPP of KZN and the DPP of Johannesburg or South Gauteng will then confer and say, look, in the interest of centralizing this case, because there are legs in our different divisions, we will agree that this case will be prosecuted in one of the two divisions. And that is the instance where both DPPs agree that the matter will be heard in a particular jurisdiction. But in those instances, then that matter will, once it's transferred, resort under the jurisdiction of the DPP of the division where the matter is being heard.
You are referring to centralization.
That is correct. That is a DPP's function. It's one of the prosecutorial functions of a DPP.
Which is authorized in accordance with Section 111 of the Criminal Procedure Act.
Is it Section 111 of the CPA?
Yes, 111.
thought the NPA Act also dealt with it at somewhere.
Yes,
need to find
it
that.
does, but it's read with Section 111 of the Criminal Procedure Act. We don't necessarily have to go into, for the moment, to go into the provisions of Section 111.
Perhaps you should find out whether the advocate has a copy of that provision.
She indicated earlier. to
I
me
don't have a
she
copy
doesn't.
of the provision, Section 101 of the Criminal Procedure Act.
I think you may have this copy for now. Let's make it easier.
Thank you, Chair.
I'm advised, Advocate Batohi, that the provision that we're talking about in the NPA Act is 22.3. Yes, 22.3. So if you centralize, it's centralized in terms of Section 22.3 of the NPA Act, read with Section 111 of the Criminal Procedure Act of 1977.
Yes, that's correct. If you look at Section 111 of the NPA Act, of the Criminal Procedure Act, that act has been amended to now reflect 1A as the NDPP having this power. But it seems like the heading in this section has not been amended, because it talks about the minister may remove trial to a jurisdiction of another attorney general. So that was pre the formation of the NPA Act in 1998, or the single prosecuting authority, where we had attorneys general that headed up each of the provinces. There was no national prosecuting authority and no NDPP. There was a minister, there was a Department of Justice and a minister. So at that point, it appears that the minister was able to move a case from one jurisdiction to another. But now Section 3 of the Section 22.3 of the NPA Act gives the NDPP the ability to centralize. And if you look at the rest of the content of Section 111 of the Criminal Procedure Act, it is aligned to the NPA Act, but it seems like they just haven't amended the heading.
Do you want to read it into the record? Perhaps you should do so. Section 111.
Section 111 1A of the Criminal Procedure Act says the direction of the National Director of Public Prosecutions, contemplated in Section 1791A of the Constitution of the Republic of South Africa, 1996, shall state the name of the accused, the relevant offense, the place at which, if known, and the director in whose jurisdiction the relevant investigation and criminal proceedings shall be conducted and commenced. Is that sufficient?
It's sufficient for the moment, Advocate Batohi, but I want to take you one step or two steps backwards. When you were dealing with centralization, maybe to make it incandescently clear, to make it more clearer, it is when an offense is committed in one jurisdiction and another offense is committed in another jurisdiction. And
That's correct.
And you deal with it in terms of Section 111 for convenience. Am I correct?
That is correct. It could be more than one jurisdiction or two. It could be three.
Could be.
But you have legs in different parts of the country. And then the DPPs would confer and decide that for convenience,
yes,
it should be in one division.
Some of us did not understand legs in different parts.
Oh,
so
sorry.
I wanted you to be clear.
Different charges and offenses
committed.
My apologies. Offenses committed in different provinces.
Thank you.
Thank you.
Now let us go to 42 itself.
I beg your pardon?
I'm saying let us go to paragraph 42 itself. You may not deal with that. Go to paragraph 46 on page 24.
Which paragraph? 24.
46 on page 24,
46.
Madam Justice, Madam Chair. Are you there, Advocate Batohi?
I am.
Yeah, as a matter of introduction, you are appointed by the President.
That is correct, as the National Director of Public Prosecutions.
The NDP, the DPP, is he or she appointed by the President? And if so, in terms of what section of the Act, the NPA Act?
That is correct. The NDPP is appointed by the President, as well as the DPPs, which I think is in terms of Section 13. I need to check that. Yes, Section 13, appointment of directors and acting directors.
It follows therefore that Advocate Chauke was appointed by the President of the Republic of South Africa
That is correct.
in the position that he's holding now.
That is correct.
Briefly, go to paragraph 49 and just in passing and in a nutshell, just explain those powers that you have in terms of Section 22(1) over the DNPPs, the DPs, SDPs, just briefly. And to also explain this oversight of the NPA.
So,
Oversight of the NDPP, rather, excuse me.
so we have read Section 22(1) into the record. The National Director, in terms of the section, has authority over, it's the entire NPA. So it would be DPPs, well, the Deputy National Directors, the DPPs, Special Directors, ID, the deputies in the divisions or in the head office, the Deputy DPPs, prosecutors, and now the IDAC. And all of the functionaries are ultimately accountable to the National Director in terms of carrying out their duties and executing their powers under the Act. I want to, maybe before I deal with that point, just to mention that the oversight of the National Director is over the entire institution, is to ensure that as the prosecuting authority of the Republic, it functions optimally, effectively, efficiently, and in doing so, every member of the prosecuting authority upholds the Constitution and the rule of law in carrying out our core powers, functions, and in terms of the mandate, and that is instituting criminal proceedings. I do want to mention at this point or explain that the DPPs in the division, and I'm not sure if it's carried, if it's, I think it's dealt with in a section that does come through under the Directors of Public Prosecutions, which is from paragraph 68 on page 30. But very briefly to mention at this point that although a National Director has overall accountability and is the head of the National Prosecuting Authority, the power to decide, to make decisions to prosecute, the original power to do so lies in the Directors of Public Prosecutions, who are the heads of each of the provincial divisions. And that is very important to understand, because sometimes it's misconceived that the National Director decides on prosecutions. The DPPs in each province are the ones that have that power And the national director cannot and should not instruct DPPs on which cases to prosecute or not prosecute, save for when they relate to priority areas. If there's a focus of corruption, then we can say that is a priority, and we can check to make sure that those cases are being dealt with. But in respect of each case, Chairperson, the DPP decides on whether to prosecute or not to prosecute, and the national director is a review authority.
Madam Chair, you seem to have wanted to address an issue with her. Okay.
Oh, I thought you were indicating to me as well, and I thought I was being rude by continuing. My apologies, Chair. Well, I'm glad to hear I wasn't being rude.
No, proceed, sir.
Thank you, Madam Chair. What you have just spelled out, Advocate Batohi, is autonomy of the Section 6 DPPs, not so.
Autonomy insofar as decisions to prosecute are concerned. That's correct.
Yes. Which autonomy you're dealing with in paragraph 51 of your affidavit on page 25?
Yes, that is correct. Sorry, let me understand your question before I say it's correct.
Line 3, you're saying such DPPs are not autonomous, but are subject to oversight.
Yes, let me explain that. Autonomous in the sense that they are not a law unto themselves. You know, they fall under the control, and the Act in fact says you operate under the control and direction of the national director. But insofar as the decisions to prosecute, they have the original power to decide to prosecute. But of course, they are part of a prosecuting authority, and they are ultimately accountable to the national director for the performance and, you know, a whole range of issues. They are required to report to the national director and ensure that there is this accountability, clear accountability line to the national director. But I emphasize, in respect of decisions to prosecute, they are autonomous in the sense that they have the original power to decide on whether to prosecute, who to prosecute, for what charges.
So such autonomy that you refer to is therefore within certain defined boundaries.
Sorry, yes, they work under the subject and control of the national director, and there is a section that I think it comes, we deal with it in paragraph 58, which we will come to, which deals precisely with this issue.
Tie it now. Let's leap over to it.
Well,
Let's hasten to go to it, tie it with the issue of autonomy, so that it can be put into perspective.
Yes, sorry. So it starts with, maybe I could just get to section 55, but dealing with the issue of the NDPP's oversight.
Yes.
It also relates to, as I mentioned in paragraph 51, they required to submit reports in respect of various aspects of the work in the division. And there's at section 24(4)(a) deals of the NPA Act, deals with this aspect as well, in order to ensure that the NDPP can exercise his or her oversight powers. It will also apply in respect of operational, administrative, financial aspects of the division. And then if we move on to paragraph 55, referring to section 23 of the Act, which provides...
Page 27, Madam.
Yes, page 27. Section 23 of the Act provides that Section 6 DPPs are to exercise and carry out their general prosecutorial functions, powers and functions, and I quote, subject to the control and directions of the national director. And a similar provision is contained in section 24(3) of the NPA Act in respect of SDPPs, which is not applicable in this case. So Then we move on to section 56, which then seeks to unpack what the control and direction of the NDPP means.
I beg your pardon. It must have been a slip of the mind. It's sections 56.
Oh, it's paragraph 56. My
not
apologies.
section, yes.
So paragraph 56 relates to, begins to deal with the issue of what does subject the control and direction of the NDPP mean in relation to the prosecutorial powers and functions of DPPs. And then it outlines in the following paragraphs what this firstly does not mean, and that's clear in section 50, paragraph 57. It does not mean that an NDPP can instruct a DPP to prosecute or not prosecute in a given case. But of course, an NDPP is required, may ask for reports, etc., with regard to cases. And in terms of the review process, an NDPP can overturn a decision of a DPP to prosecute or not to prosecute, which we dealt with earlier today. And we then deal with, just continuing with the oversight.
Perhaps before you proceed on the oversight aspect, Council,
Yes.
it's paragraph 52 and 53. Before I ask the question, of what relevance are they to our purpose?
Chairperson, I think it just deals with the structure. That's correct. It's not particularly relevant, but explains the structure of the NPA.
What is
And-
ONDPP?
Oh, my apologies, Chairperson. That is the office of the NDPP. So let me explain that, Chairperson. We talked about the different business units in the NPA. Well, we talked about one business unit. So let me explain the structure, Chairperson. You have a national director. There are 4 deputy national directors of public prosecutions in the NPA. The deputy national DNDPP is deputy national director. The deputy national director in terms of the NPS referred to in 52 is the National Prosecuting Service. That is the DNDPP. That deputy is the one that all the DPPs report to the national director through this deputy. So this deputy sort of manages all the general prosecutions, the DPPs in all the provinces. The direct supervisor is the deputy DNDPP for NPS. Then the next business unit, there's four DNDPPs. Just for understanding, it's not relevant, pertinent to this case, but the other deputies are a DNDPP that heads up the asset forfeiture unit, a DNDPP that heads up the strategy operations and compliance unit. And at the moment, we just have three DNDPPs. There was another DNDPP who was retired and was heading up the legal affairs division, but at the moment there are 3. So those are the 3. And ONDPP is the office of the NDPP.
You earlier on dealt with the question of autonomy in relation to the exercise of discretion, whether to prosecute or not to prosecute. In paragraph 53, the third or the second line, you deal with a matter that seems to be touching on that issue of autonomy of a DPP. Would you explain what that last sentence means, starting from what this entails?
Certainly, Chairperson. What this entails is that DPPs may institute and discontinue. Chairperson, this was an explanation of the structure of the NPS, that's the National Prosecuting Service. And what was being explained there is what is set out in that paragraph is what I was explaining a short while ago, is that the DPPs in the provinces, they carry out their functions subject to the control and directions of the Deputy National Director, who's responsible for NPS. So they report to the NDPP through the DNDPP NPS, who's the head of that business unit. Service, that's correct. The NPS. All general prosecutions are conducted in the NPS. The IDAC now is outside of the NPS, but for all intents and purposes now, all prosecutions, except for the IDAC prosecutions, resort under the NPS, and the others are more specialized units: asset forfeiture and strategy and operations and compliance. That's not correct, Chairperson. The decision to prosecute or not prosecute is the DPP's. The original power is the DPP. It is more a managerial function and oversight that resorts in the Deputy National Director, who is, of course, has the delegated authority. A DNDPP can act as a national director in terms of the act and has the same powers, functions, but it depends on what a national director decides will be a specific area for a DNDPP. So to be clear, they are not able to direct or instruct a DPP with regard to the prosecutorial, the decisions to prosecute or not to prosecute.
I suppose the problem may be emanating from the fact that we have only a portion of the Mokoro report reflected on that paragraph, and it's confusing.
Yes, and the context perhaps is not clear.
The context is not there.
Yes.
Because if this is correct, that seems to go against what you earlier said about the independence of the DPP.
Let me read this carefully again, Chair. I didn't think that it said that. Just a moment.
Let me just read it aloud. So what this entails is that DPPs may institute or discontinue criminal proceedings and carry out any related functions in their area of jurisdiction subject to the control and directions of the DNDPP.
Chairperson, that's correct. If you consider this exact same language applies to a national director. The DPPs conduct their functions, all their functions, subject, if you look at the act, the DPPs act under the control and directions of the NDPP. Maybe we should just go to the section. It's section 23, which says that section 6 DPPs are to exercise and carry out their general prosecutorial, that's paragraph 55, their general prosecutorial powers and functions subject to the control and directions of a national director. So that's the same language that we use in paragraph 53 with regard to their relationship to the Deputy National Director in charge of that business unit. But we then go on to explain what subject to control and directions mean. And maybe I should, in the first section, paragraph 57, it's mentioned that it does not, what does it not mean? And the same would apply to, it does not mean this in relation to their relationship with the DNDPP as set out in paragraph 53. It does not mean that if an NDPP exercises his or her review powers, let me just continue here, review powers of a decision to prosecute or not to prosecute, that he or she, acting in terms of these provisions and complying with the procedure or processes prescribed therein, may overturn the decision of a DPP to prosecute or not prosecute. Let me read it properly, Chair. I'm skipping parts of it and it's not helping any one of us.
I'll tell you what my concern is there. it talks to the autonomy of the DPP
That's right.
insofar as the exercise of his or her discretion is concerned.
Prosecutorial discretion, that is correct. And the point made here, Chairperson, is that it does not, firstly, in the first paragraph, it does not mean that that's 57. It does not mean that an NDPP can instruct a DPP to prosecute or not to prosecute any given case. And if you read section 58, if the converse was true, that subject to the control and directions of the NDPP means that an NDPP can, outside the scope of section 1795 of the Constitution and section 22(2) of the Act, NPA Act, instruct a DPP or prosecutor, and the same would apply for a DNDPP, instruct a DPP or a prosecutor to prosecute or not to prosecute. This would render nugatory or undercut the NDPP's review powers over such decisions which the legislature could not have intended. It would also be inconsistent with the constitutionally enshrined principle that DPPs are responsible for prosecutions in their respective areas of jurisdiction. And we come to the DPP's powers in paragraph 68 in 2 pages, which will clarify maybe this, what appears to be a lack of clarity. From paragraph...
Before you proceed, Advocate, please put my mind at rest that wherever you're going, you are going to help us understand what is contained in paragraph 56 of your affidavit, especially in quotation marks where you say subject to the control and direction of the NDPP, as opposed to the autonomy that should be enjoyed by the DPP, so that you clear the confusion and the misunderstanding.
Sure.
In order to do that, I think we first need to go to perhaps section 23, section 24 read with section 23 of the NPA Act. If I can just go there. So section 24, and then let me look at section 23 so that I can deal with them properly. If you look at section 20 deals generally with the powers of members of the prosecuting authority to institute and conduct criminal proceedings. Section 23 reads, subject to the provisions of the Constitution and this Act, subject to the provisions, any director shall, subject to the control and directions of the National Director, exercise the powers referred to in subsection 1 in respect of the area of jurisdiction for which he or she has been appointed. And of course, the powers in subsection 1 are set out. Now, if you read section 24, which deals with the powers and duties and functions of directors, it reads, subject to the provisions of section 179 and any other relevant section of the Constitution, this Act, or any other law, a director referred to in section 13 has, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings. So this power, the original power to do this, is given to the DPP of a division, not to the NDPP. And so the power of the national director, or let me say the control and direction of a national director, must be read in conjunction with this section, which gives the DPP the original power to conduct and institute criminal proceedings. And as I say in paragraph 58 that this is the case because the national director is a review authority. And so the national director, in order to be a review authority, it would actually, if the national director is actually involved in the decisions to prosecute, then of course you would not be able to conduct your functions as a review authority. So it's got to be the control and direction of an NDPP extends over various aspects of management of the entire prosecuting authority. So, the DPP can submit reports with regard to cases. The national director can query the pace of cases, whether any additional support is needed for cases, look at the performance of the division, look at issues relating to HR, finance, administrative functions. But the function of the DPP, insofar as the power to institute prosecutions, is clearly set out in section 24(1)(a), which gives the DPP that authority, and the Act gives the NDPP review powers over a DPP's decision. So
it is the language in paragraph 53 that is creating a problem there. When you subject the exercise of that discretion under the control and direction of the DNDPP. And that's why I asked, what is the impact of this on the independence of the DPP then?
I accept, Chairperson, that the way it's structured could create that confusion. And my apologies for that, but hopefully it has been clarified.
I have a follow-up question. The provisions of section 24(1), the powers conferred on the DPP, are they exclusive? Because from the reading of the section, I don't see exclusivity, and it takes me back to the issue of autonomy. Is it you interpreting the provisions of the Act, or is it the Act explicitly saying that to us?
Chairperson, it's the Act that is explicitly saying it to us. If you read section 24(1)(a), it states that subject to the provisions of section 179 and any other relevant section of the Constitution, this Act or any other law, a director referred to in section 13(1)(a) has, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings. So it is explicitly mentioned that that power vests in the DPP.
Thank you, Council. You may proceed, Council.
Thank you, Madam Chair.
In fact, I think you can tie up this section because we're going to adjourn at 4 o'clock in a few minutes' time.
Let me do so. Thank you, Madam Chair. Now, you explained the autonomy of an NDPP, his or her powers, as set out in section 24. But I want us to take it just one step forward. If you read section 24, you have to read it with section 20. Section 24(1), you have to read it with section 20. The power to institute and conduct criminal proceedings, where a prosecutor or a section 6 DPP can institute and conduct criminal proceedings and even discontinue criminal proceedings. Am I correct?
That's correct.
I'll leave it at that, Madam Chair. For today, at least.
Thank you. Thank you, Council. Thank you, Advocate Batohi.
Thank you, Chairperson.
We are going to adjourn until tomorrow morning at 10 o'clock. Council, you'll continue from where you left now.
Yes, Madam Chair, I will do that.
And before we adjourn, may I just address the issue of transcription. I know Council raised it yesterday, and we learned when you adjourned that we had the record yesterday when you adjourned, but there were some errors. I suppose that was brought to your attention when you arrived at the offices. But we will have a continuing or running transcription every day, meaning that you'll get it the following day. Is that clear? And I suppose with all records, sometimes you find names being incorrectly spelled. I've already seen my name is very badly spelled somewhere. But it is okay, we know that I am who I am. To that extent, I think let's take an adjournment to make it possible for all of us to travel to our different destinations timelessly. And tomorrow we start at 10 o'clock. We adjourn.